Chairman, let me take this opportunity. I have a preliminary fundamental objection to us proceeding with the vetting of my colleague. I have no problem with his person. I know that he's member of parliament. But Chairman, I have here letter dated 21st January 2021, signed by President Nana Addo Dankwa Akufo-Addo. It has a subheading Central Government Ministry 29 Public Enterprises, Honorable Joseph Cudjoe, Member of Parliament. And Chairman, I have also in my hand here Executive Instrument EI-12, Civil Service Ministries Instrument 2021, and it reads, in exercise of the power conferred on the President under Section 11(3) of the Civil Service Act 1993, PNDC Law 327, this instrument is made this 22nd day of January 2021, and Chairman, it lists ministries of the civil service, and it ends at Ministry of Youth and Sports. Conspicuously lost in the EI is the Ministry for Public Enterprises. Is a Ministry for Public Enterprise, as I indicated in 29 of the present list. So, if we do proceed to vet the Honorable Cudjoe, are we vetting him as Minister for State, Minister heading a secretariat? Because within the meaning of EI-12, there is no Ministry for Public Enterprises. More importantly, as I go further to dig to appreciate what his role will be, and that is what the EI will do, I see State Interest and Governance Authority Act 2019, Act 990. But I know that there was an earlier statement from the Office of the President on some of these matters. So, Chairman, I'm demanding clarity. What are we seeking to do? Are we considering the Honorable Joseph Cudjoe for a non-existing ministry, which is not a creation of law or a creation of statute, or we are just considering him? I have no issue, and I can have no issue in questioning the mandate of the President under Article 78, which gives him the executive authority to appoint ministers. But he must do so in accordance with law. To what ministry is Honorable Joseph Cudjoe going? There is no ministry created by the executive instrument EI-12. So I want to raise this fundamental objective, Chairman, as we proceed, and probably request the Office of the President to provide more clarity and guidance as we proceed. There is no Ministry for Public Enterprises. So I raise this objection. Thank you, Chair.
Yes, Vice Chair.
Mr. Chair, thank you for the opportunity. I've heard my respected colleague loud and clear. I understand one arm of his objection. That is, the EI as published does not include the portfolio expected of the nominee. But what his submission was silent on was the issue of whether or not the President can make an appointment at the presidency, a Minister of State responsible for a sector at the presidency, whether or not that will require an EI specifically detailing a specific ministry for the purpose of that office. If I heard my colleague clearly, all he's saying is, if the nominee is going to operate at the office of the President and in charge of a specific portfolio, he has no objection. It is only when he is going to have a ministry under him that he would have an objection, and that will be rightly so per the EI-12. So, Mr. Speaker, Mr. Chair, my view is that this is not the first that we getting a nomination. Honorable Dr. Kweku Efriye, MP for Sefwi was appointed a Minister of State at the presidency. We've had ministers of state appointed even at specific ministries. So I would want us to construe his nomination not as one for the purpose of running a ministry, so that that clarity that he seeks will be so understood in that context. Unless otherwise, his second contention is that every minister of state so appointed, nominated by the president, proud to come into the House for confirmation, would necessarily have to be assigned to a particular ministry with that structure of a chief director, civil servant operating under him. Thank you, Mr. Chair.
Chairman, if the deputy leader listened to me, I am not in any way questioning the authority of the president under Article 78 to appoint such number of ministers as he deemed fit and desirable. But by the letter dated 21st January 2021, is listed central government, ministry, the name indicated. At 29 is public enterprises. So ministry. So it's presumed that there will be a ministry for public enterprises. I will come to the duplicity of it. At a personal level, I will not support a ministry for public enterprise because every ministry is a public enterprise of a sort or is engaged in a public enterprise of a sort. But if the president is appointing him as Minister of State to be responsible for maybe, as I said, I also referred to State Interest and Governance Authority Act 2019, Act 990. There are many agencies under the presidency that normally a president will refer to a minister to supervise, like MIDA, like Ghana AIDS Commission. There are many of it. But I'm saying that if we proceed further with the scrutiny of our colleague, is confirmation, are we doing so within the correspondence from the president, which is not sitting with EI 12, the executive instrument, to which he has exercised his power and mandate? You know, we should not encourage the executive to just take parliament for granted. Yes, it's your power to do, but do so within the law. So the Ministry of Public Enterprises is not a creation of statute and is not recognized by EI 12. So accordingly, I'm demanding clarity from the president, maybe through you. He should just give us a formal letter clarifying the status of this minister. But we have no objection. We recognize that he's a member of parliament. He meets the minimum requirement to be minister per Article 94 of the Constitution. But the president has a fiduciary duty to the law. And I find that unsatisfactory at present. Thank you, Chair.
Mr. Chair.
Yes.
With that clarification of thought and that extended submission, I have no other option than to agree with Honorable Haruna Iddrisu that further clarification on this matter is well, grounded. That, however, would not mean that we will put our vetting of Honorable Cudjoe on ice. Yes, I mean, if we are House of Record. Hold on, we are House of Record. If at any point we want a clarification on a matter, we don't hold back and say that until that is clarified. I don't think that was part of his prayer. I am saying that if we agree generally that there's a need to clarify and all that. After all, it is not the first time that any matter relating to a nomination of which a member wants clarity has come up. It's not the first. So I have no objection in principle, except that we can proceed whilst we seek to get that clarification given.
Honourable members, I think that there are two issues before me. The President wrote to Parliament, the Minister, the list of persons he has nominated for various positions. The Speaker referred the list to this House to consider and report to the House. That is our responsibility. Our attention has been drawn to a list contained in an executive instrument in which a particular alleged ministry is missing. We would draw in our report, we would draw the attention to the House that we found that EI 12 did not list the public enterprise as a ministry. So in considering the report, the House or the executive instrument or the executive may seek to rectify or the intent to use him as a minister of state without portfolio, whatever. But our responsibility is to consider the nominees as referred to us by the Speaker and report to the House. Thank you. Now we'll proceed with the consideration. Yes, Honourable Member for Boko Central.
Thank you very much. Mr. Speaker, Chairman has given his ruling on the matter, so I will not go back to that issue. But just to ask the nominee, Minister-designate for Public Enterprises. What are public enterprises? What is the state of our public enterprises? And what will you be doing as Minister for Public Enterprises? He has given a ruling. Chairman has given a ruling. Chairman has given a ruling on the matter.
Thank you, Mr. Thank you, Honorable Chairman. Public enterprises, I'll take the question in the order you asked them. Public enterprises are categorized as the state-owned enterprises, joint venture companies, JVCs, and other entities which the government has looks on them as commercial entities in that category. We call them the public enterprises, and different from the public services, distinct from public services. When you ask the second question, which relates to the state, examples of public enterprises.
Mr. Chair, with your indulgence, Honorable Nominee, you mean to say enterprises that government has a major stake? I'm saying you mean to say other enterprises that the government has a major stake?
I would rather use government has interest, and that's interest not necessarily major, because mining companies where government has 10% stake by way of royalty rights. It's part of the public enterprises. And there are joint venture companies in which government doesn't have majority shareholding, and they're still in the category of public enterprises.
So if government buys 5% shares in Accra Brewery, does that make it public enterprises? Or are you minister in charge of government's interests in public enterprises? Because there's a difference between being a minister in charge of government's interests in public enterprises and minister in charge of public enterprises. Because public enterprises are public enterprises. Government haven't bought shares in enterprises. Is that okay? Is interest in enterprises. Because I noticed that there's some confusion going on in what should actually be public enterprises. So what will be your mandate? Will you be managing government's interests in every enterprise, or you will be overseeing just public enterprises as defined under our Constitution? Because the Constitution defines public enterprises and corporations.
Thank you, Honorable Chair. I will refer your committee to the State Interest and Governance Authority Act, 2019, Act 990. And in this, when we were passing this act, a provision was made for the position of the minister to be responsible for SIGA, and that is SIGA, State Interest and Governance Authority, which was created by this act. And Honorable Chair, the act, as I show a copy to you, mentions the minister responsible for oversighting SIGA, mentions it 18 times in this act, which was passed by this House. And the interpretation portion clarifies the role, the meaning of the minister in respect of this act. The 18 times mentioned gives clear and distinct of something I would call job description or role of the minister to oversight the administration, effective administration of this act as passed by this House. SIGA has been working, it's been in existence since the passing of this act and making sure that the provisions. So, SIGA has about 86 declared or specified public enterprises. And the role of this ministry is to oversight them. Some government has a minimum of 10%, some 100%, and some 20% and so on. But government interest, like you are saying, government interest in these public enterprises are what this ministry is created to oversight. Thank you.
So would you say that your definition of public interests, a public corporation or public corporation is that which has been defined by the Act?
Yes.
Yes, sir.
Chairman, yes.
So this is not your definition, but that which is in the Act?
Yes, Chairman.
Very well.
So in essence, the ministry's role will be to oversee public enterprises and to also oversee the interests of the state in other enterprises that may not necessarily be, corporations, state-owned corporations, and etc. Wherever, in any other enterprise in which the state has interest, then the ministry will be responsible, or the minister will be responsible for overseeing the management of that interest.
Exactly so, Chairman. Yeah.
So the second part of the question.
The state of public enterprises today, as we can all identify with, include high losses. The high losses of these enterprises, indebtedness, and low productivity, low efficiency, weak governance structures also exist to ensure that they operate profitably, and also there is fragmented coordination of the government interest to oversight these enterprises. when it comes to the profitability, efficiency issues, this we all know has been a drain on government resources because government invested for returns, but that is not what is happening. That is the state now, and that presents problem to be solved. And that is what His Excellency, the President, is trying to focus attention on, to make sure that this situation is addressed. Thank you, Chairman.
Chairman, with your indulgence, we have, as I've indicated, Honorable Cudjoe is one of us. My objection, I think, is fundamental. I would wish that you relate to the presidency just to give us a formal official correspondence to enable us proceed, even if it takes midnight with the correspondence from the presidency we will do. But as we proceed, there is no Ministry for Public Enterprises, and our hands are tied because we should be assessing him based on the role he's going to play at that particular sector. So, Chairman, I'm making an application to you, and your ruling, the Constitution supersedes an EI. I have said that I have no difficulty with the President exercising his mandate under Article 78, but we are vetting him for what purposes? So, Chairman, if we can, we allow us to do consultation momentarily for 5-10 minutes. But I think that you and the leadership must be reaching out to the President to provide further and better particulars for us to proceed. I'll plead with you, Chairman. Allow us 5 minutes, then I do a consultation, and then we proceed. To Honorable Cudjoe, bear with us. We are following fidelity and respect to the law. Chairman has done
instructions. That's not the challenge. Obviously, we are discussing this. That's if we have come to a conclusion.
Mr. Chair, if I may have the floor. Mr. Chair, if we give due regard to Article 78(1) with respect, quote, ministers of state shall be appointed by the President with the prior approval of Parliament from among members of Parliament or persons qualified to be elected as members of Parliament, except that the majority of ministers of state shall be appointed from among members of Parliament. So, Mr. Speaker, Mr. Chair, fundamentally, the nomination by the President, the effect is that the person becomes a Minister of State and not appointed to a particular ministry. I have said, and I'll repeat, that the fundamental issue of clarity raised by my respected colleague is well grounded. But if you look at how it is situated, it is only in form. In substance, a Minister of State has been nominated for vetting here. So the ministry has attached to it that he is saying that, look, he sees that there is some omission. To what extent does that stop us from proceeding? If the intention is to get clarity, then my view is that as Parliament, we can proceed. What we are doing now is not a finality. In fact, after vetting, we will not even take a vote now, or that we are not the plenary. I therefore hold the humble view that the earlier position by Mr. Chair, that we can proceed whilst immediate steps are taken for clarity on this matter, would not in any event, have any serious effect on our work. It would rather help us proceed as time is of the essence and as the supposed defect is not so fundamental. So I would humbly plead with the Honorable Minority Leader that it wouldn't hurt to proceed whilst the very clarity he seeks to get is pursued by the chair. After all, he is part of the leadership of this committee. So the communication will be transmitted to the appointing authority for clarity. I thank you, Mr. Chair.
So, Chairman, my application is still before you. It's not my intention that we take sides in this national exercise, but momentarily for Honorable Cudjoe, our side will just sit and observe whilst we wait for clarity and better particulars from the presidency. We do not intend to take part in further proceedings until we receive satisfactory explanation from the office of the president. So that will be our attitude to his vetting. Thank you, Chair.
Very well. But there's this point I must make clear. I think there are certain matters which require decision by the committee. And so if we have raised issues like this, you raise it at our pre-sitting meeting or pre-sitting, we'll discuss them and take a decision. I think we should not continue to jump matters after we have brought in a nominee and sworn him for consideration. The second one is that I think it's totally inappropriate for me, sitting here as a committee chairman, to take a matter arising out of here to the presidency without going through Mr. Speaker. We're a committee of the House. Matter is brought before us at the committee, we report to the House, and in particular instance through Mr. Speaker. I don't think I should be able to go behind Mr. Speaker to speak to the presidency in matters like this. So let's proceed with what we can. It's noted that an objection or a question is raised as to a ministry not created, so to speak, which will be contained in our report that this matter was brought to our attention as a committee, and we draw the House's attention to it. But please, let's proceed. Yes, Honorable Bob.
Mr. Speaker, Mr. Chairman, I think you've made a very good point, but I suggest that we've been sitting as a committee and we've worked closely together up to this point. If we could give ourselves some 10 minutes off camera to discuss some of these issues that they've raised. Say again. We should proceed. If the chairman has ruled, fine. But I was thinking we should, because we've worked closely to this point, and this is not a matter that should break that cordiality. We should go off camera, sit and resolve this in 5 minutes. I don't think a phone call to seek clarity will spoil anything. Thank you.
Yes.
Mr. Chairman, thank you very much. Mr. Chairman, I strongly support the suggestion by my respected colleague, Honorable Patrick Boama. 10 minutes, because we are here to work and we are willing to work. We have nothing personal against the nominee. It's just a fundamental legal issue our leader has raised. So let's not, as it were, affect the cordiality and congeniality with which we have worked thus far. So, Mr. Chairman, I don't think 10 minutes to go into conclave and seek further clarification from Mr. Speaker and His Excellency the President will hurt. Just 10 minutes, Mr. Speaker.
Do I have consensus on that?
Chairman, if you listened to me earlier, I requested for this. I said we should just have 10 minutes consultation. I only came in when that was kind of not respected. I did so. If you want to go back to the record, I couldn't have. That's when you even said that we should take a decision as a whole. I did. I said just 10 minutes consultation. I have nothing against the nominee, but we just want respect to the law.
was asking whether we have a consensus on suspending and doing.
No, just 5 minutes consultation. I think so. 5 minutes.
Very well.
To the extent that we are making this call in good faith and we hope to maintain the good atmosphere, why not? To the extent that we mean well and we want to do so, why not?
We will discuss all that when. Yes, so the nominee will kindly excuse us. We will call you back, please.
Thank you, Chairman.